For the state of Kansas section, the Honorable Aaron Arnold Berger presiding.
Hi, good morning. You can see Welcome to the morning session of the Kansas Court of Appeals. This is really a bittersweet day for us up here. We are honored to be here with Judge Henry Green on my right, who is the longest serving judge on the Court of Appeals. And this will be his last docket today. And it's also fitting that we're going to look at it, right? There is his portrait as we hear these last cases. So you guys are here for a really special day today. We're going to get choked up. But I'm Karen Arnold Berger. I'm the chief judge of the court. I'm the presiding judge today, which all that means is I get to keep time, and I'm not very good at it. So you'll see that very quickly. Of course, on my right is Judge Henry Green, the longest serving judge on our court. In January, when he leaves our Topeka courthouse, he will have been on the court 32 years. On my left is Judge Steve Hill from Miami County. He was a district judge before he was on the bench, and as of last week, he is now the longest serving judge in the state of Kansas as far as total number of years that he's been a judge. So we've got a lot of experience on bookend here with me. So I'm going to call the docket, make sure everybody's here, and then I'll call you up one at a time. First, we have 126411 Rodina versus Castaneda. Are the parties here on that? Okay, I'll have you enter your appearance when you get up here. State of Kansas versus Abram Slaughter. Okay, great, thank you. And State of Kansas versus Adrian Newsom. Okay, great, thank you. You will all get, you'll each get 15 minutes to argue your case. If you are the appellant and you would like to reserve rebuttal time, just let me know that so I can keep track of that for you. We have read the briefs in your case. In many cases, we've read the record of what happened in the district court. So you only have 15 minutes. You really don't have to spend a whole lot of time talking about the facts unless there are particular facts you want to highlight, because we covered those already. And don't be surprised if once you get started, we immediately start asking you questions and throw you completely off your game. So I apologize for that, but often that's the best way for us to fully understand your case. So with that, I will go ahead and call the first case today, 126411, Rodina versus Castaneda. Parties would step forward, and I would mention we are live streaming today. So your clients or others can watch this on YouTube or our court website, and it will also be archived so you can watch it later and impress all your family with your with your wonderful presentations today. Okay, so the appellant, Mr. Rodina, who appears for him?
Good morning, Your Honor. Kyle Branson appears for Curtis Rodina. Curtis Rodina is actually the appellee across the country.
Oh, I'm sorry. I just looked at appellant as the last word there. You're correct. And Mr. Castaneda?
Your Honor, Andrew Holder on behalf of the appellant, Dr. Castaneda.
Okay. All right. So, Mr. Holder, did you wish to reserve any time for rebuttal?
3 minutes, Your Honor.
Okay. All right. Go ahead and get started. If you see me looking at my phone, I'm not texting. I'm just trying to keep time with it. You'll see quickly how that.
Your Honor,
right.
Can I have first the podium or where would you?
Oh, yes, please do.
Okay, thank you.
See, now I turn the flash. Okay. Got it.
May it please support Andrew Holder on behalf of the appellant, Dr. Castaneda. This is a case that derives from a perfect storm of procedural issues. I'm going to do my best not to go over the facts, but I think the procedure here matters to
Okay.
good in this case. So the case starts with an entirely separate lawsuit filed by the appellee, Mr. Rodina, against 3 non-parties to this appeal. And the central premise of that lawsuit was that the defendants in that case wrongfully withheld the identification of the dentist who treated Mr. Rodina. Dr. Castaneda, my client, the appellant, was not a party to that lawsuit. He had no notice that it was going on or any ability to join or have any say in that lawsuit. The central claims in that case were for violations of HIPAA, violations of the Kansas Consumer Protection Act, and for breach of contract. There was no verbally stated negligence claim in that lawsuit, and none of the defendants treated Mr. Rodina. So there really was no party who could have provided negligent dental care in that lawsuit. Nonetheless, I think that the record, which is part of my brief and part of the record before this court, shows that the district court did end up awarding damages for pain and suffering, which really only could have been awarded as part of negligence action. Those were not recoverable under any of the theories that were pursued. So the net result of that was that a default judgment was entered against the defendants in that case. Subsequent to that default judgment, which again, Dr. Castaneda did not participate in any way, was not on notice of. A second lawsuit was filed against him, this time for medical dental negligence. And that case went up to appeal after a motion to dismiss was granted. The Court of Appeals reversed the motion to dismiss, finding that the one action rule did not apply because the default judgment in the first case, which I'll call the Taylor case because it's a little less of a mouthful. The court found that because the district court had not entered an allocation of fault in the Taylor case, that the one action rule did not bar the claim against Dr. Castaneda.
Do you disagree with that ruling?
It's a difficult question to answer, and the reason is because
that's why I asked. I'd like an answer.
I don't disagree fundamentally with the concept that if there's been no allocation of fault in a prior case, that the one action rule doesn't apply. What gets messy in this case is I don't think that there should have been, I don't think that there was negligence claim in the first case, so I don't think that there should have been a default judgment for negligence in that case. That's the part where I think I diverge from the opinion.
Is that the position you took in the district court?
At the district court, following the appeal, yes, Your Honor. When the case
following the appeal.
Right. I was not the attorney in the prior case. I mean, the motion to dismiss was filed because we did have a judgment that included damages that I think were apparent for negligence. The court ultimately said that the one action rule didn't apply. I think that's the part of this that we're resolving the issues that came after that at this point.
And our court remanded.
That's
first it remanded, saying that there needed to be an apportionment of fault, correct?
That's correct. But and I think that
that was the mandate.
That's correct.
And did the district court follow the mandate?
The district court followed that part of the mandate. Where I think the district court got sideways is treating the court's directions about the damages from the first case as finding as part of the mandate.
Why was it not part of the mandate?
Because there is no case law under interpreting the one action rule that says that a prior case in which some sort of resolution is reached that doesn't involve an allocation of fault, that whatever that resolution is sets the damages in the subsequent case. The only part of the court's ruling in the first appeal that should have been, and I believe was part of the mandate, is the finding that because there was no allocation of fault, the one action rule did not bar the claim. That there is no case law cited in any of the briefs or in Kansas case law that says that a prior case sets the damages. Most of the cases that the court talked about in that case involved a first lawsuit that got settled.
But didn't you argue in the district court that the damages were liquidated?
No, Your Honor.
What was it, $285,000 or whatever that was?
The argument was that the court had set those as part of a negligence claim, and that because there were multiple defendants, although the court hadn't assigned a complete percentage of fault, ultimately, when the court found multiple defendants liable, it established 100% fault. That was the argument that the Court of Appeals the first time around.
But on remand.
On remand, Dr. Castaneda filed his answer, and he continued to challenge damages and continued to assert that the claims that he had a right to have his damages decided by a jury in this case. Ultimately, the judge struck those portions of the answer, and the case was tried solely on the issue of comparative fault, and Dr. Castaneda never had a chance to have a jury decide the damages in the claim that was brought against him, which is part of the issue here. I think that there are really two diverging paths the court can go down. Either the statement in the first opinion that Dr. Castaneda was correct, that the damages had been set in the first case. If that's not part of the mandate, then what the court has to do is evaluate whether there's any viable basis for the district court to have treated those damages as binding. But even if it is part of the mandate, it's our contention that Dr. Castaneda's Section 5 right to trial by jury has been violated because this is a common law negligence claim against him, for which he had a right to trial by jury as a defendant. And there's case law, including the Arnett case, which I cited in my brief, that I think is directly on point here. In that case, the Kansas Supreme Court evaluated a statute that allowed a district court to enter restitution orders in burglary cases. And what the Kansas Supreme Court said is, if the remedy there should have been a civil action by the victim. And if you're taking the jury out of the equation by allowing the judge to decide the damages, you're violating the criminal defendant's right to trial by jury.
Does the mandate rule in any way affect your argument?
The mandate rule, I think my argument falls right in line with the mandate rule. I think what I disagree with is what the mandate here was. If the mandate here was that the one action rule doesn't apply, go try this like you would any other case after a motion to dismiss has been denied, then I think it falls right in line with the mandate rule. I think, and I've cited case, I think that you've got to look at what was essential to the court's opinion. And the type and amount of damages that were awarded in the default judgment here is not essential to whether the one action rule applied. So I think that part falls outside of the central holding at the Court of Appeals level, and so it should not be treated as part of the mandate. And I think if you get to that level, then we've got to look at, did the district court have a good reason to treat the damages that were set in a totally different case involving totally different defendants that my client had no ability to meaningfully challenge as the binding damages here. And I think that there is no basis in the law for treating those as binding. The one action rule certainly doesn't allow for them to do that. I've covered that already. I don't think that there's a viable argument that Dr. Castaneda was in privity with these other defendants. I think if the court takes a deep dive into what the actual claims were that were filed in that first case, there should never have been any damages awarded for non-economic damages, which is 200,000 of the 285,000 total damages that were issued here. And I think that although Dr. Castaneda doesn't have standing to directly challenge that, he has direct standing to challenge the district court's reliance on that part of the verdict here. I think that the rules for default judgment pretty clearly say that where a default judgment differs in kind from what was asserted in the petition, that part of the default judgment is void. And that petition is in front of the court. It's not susceptible to any debate about what it says or doesn't say. Like I mentioned at the front end of this, none of the defendants in that case were capable of committing medical malpractice, and there's no claim for medical malpractice asserted there. So I think that no matter how you slice it, the court has to grapple with the Section 5 problem. But if the court finds that the damages part was dicta and not part of the mandate, then it can simply find that the district court incorrectly interpreted what the mandate was and had no other good reason to find that the damages from the prior case applied. So either way, like I mentioned at the start of this, it's a procedurally tricky and complicated case.
Are you familiar with Childs versus Williams?
I believe so. Which, if I'm remembering correctly, that's probably what I would call the most recent one action case, other than there was a Supreme Court one, the Hodges versus Blanca, that just came out.
The second motion, the second action after a friendly suit.
Right.
How does that affect your argument?
Well, I think that it matches exactly what I'm saying. I'm not arguing here that the first case is barred by the one action rule. I mean, that ship has sailed. I think that it affects us in the sense that if what the district court was correct, then the child's case would seem to suggest that that in the second viable case after the settlement, the damages should have been capped at the amount of the settlement, but it didn't hold that.
Let me see if I understand what you're asking for in terms of relief. What are you asking?
Your Honor, I'm asking for a trial, essentially a redo from the point of the remand because the district court misinterpreted the remand.
A trial of
the liability and
damages or both?
Liability and damages, Your Honor. We've identified errors with regard to what the jury was allowed to consider on the issue of comparative fault.
So you're asking us to disregard the first trial, the first judgment.
Are you talking about the Taylor judgment, Your Honor? I'm not. Yeah, to disregard the Taylor judgment in the sense that that judgment was for different claims against different defendants. And so what Dr. Castaneda is entitled to is a determination of by a jury to what the damages in this case were and whether he bears any comparative fault for those damages. I do want to touch on briefly on the issue of comparative fault because I think that it's important and it's not directly tied to the procedural issues I've been talking about. But with regard to comparative fault, I think that the standard for determining whether a jury should get to decide that is deferential. And if there's any way that a jury could side with the defendant, the jury should get to decide comparative fault. I've provided the court with specific citations in the testimony, and to make the issue very clear, there's about $85,000 in economic damages. A portion, although not all of that, has to do with many dental implants that were installed in the lower jaw of Mr. Rodina. And essentially what I believe the testimony shows is that Dr. Castaneda did not install those many implants. A different dentist, Dr. Jones, installed those. And Dr. Castaneda provided testimony indicating that in his opinion, the many implants were not installed at the correct angle to allow for the partial denture that Mr. Rodina was wearing to work properly. And that I think that there's expert testimony from Mr. Rodina's expert that looks at x-rays prior to Dr. Castaneda ever treating Mr. Rodina that identified problems with the many implants. So I think that, applying the correct standard to that evidence, I think that a jury should have been entitled to evaluate what and assign comparative fault to Dr. Jones in this case. So I think as between those two, we've got clear issues with both liability and with regard to damages here. And so for that reason, I would request that the court reverse the district court's decision and remand this for a case on trial damages. And with that, I've got time left.
Okay.
All right.
Thank you. All right. Yeah, you still have 3 minutes for both.
Your Honors, this case is obviously unique in terms of where it's been and how we got back here. And I think that's important from my client's perspective. And obviously my client's now passed away, as the court knows, but from my client's perspective, he had a lawsuit. There was no response to that petition. That case went to default. There was a hearing to determine damages that was held. There was a second lawsuit that was dismissed by the court. It was appealed. He was successful on appeal, and there was a mandate from the court in terms of what was to happen next. That case proceeded. It happened. There was a jury trial. There was a determination of liability, which is exactly what the court ordered, and it was concluded. What the appellate is now asking this court to do is essentially ignore everything that I just said and everything that has happened and start over from scratch. Respectfully, Your Honors, I think that's crazy. There's a constitutional argument that the appellate makes that his right to a jury trial has been violated. He had a jury trial. He had an appeal. He had a jury trial. And now he has another appeal. And respectfully, I think the crux of the appellate's appeal in this case is essentially asking this court to revisit.
He didn't participate in that first trial at all.
The defendant, Your Honor. Mr. Dr. Castaneda, not counsel.
But the point is, in that first trial, there was a determination of damages, but there was no determination of fault. There wasn't even a dentist named in that. Well, by title, there was a dentist named. There wasn't any consideration of fault at all. And this is a negligence action, correct?
So yes, Dr. Castaneda, correct.
But wasn't sued.
Dr. Castaneda was originally sued, Your Honor. That's absolutely correct. And if I may, the reason for that was at the time, my client had been a longtime patient of Dr. Timothy Taylor, who was a dentist and was sued in the initial action. However, Dr. Taylor was not the one that had been working. And my client informed me that he had multiple different dentists in Dr. Taylor's office, but he didn't even know their names. He would get a different dentist every time he went in there. And he didn't know who it was that was actually treating. So at the time of the original lawsuit, the best we could do was sue Dr. Taylor and the practice and Ms. Cummings, because those were the individuals my client knew.
So you get a default judgment.
So we get a default judgment.
And this doctor is never named.
Dr. Castaneda was not named in the original lawsuit.
And so is he entitled to a determination of fault? That's what our prior opinion said, correct?
Correct. Yeah. And that's exactly what happened.
Now, is he entitled to a determination of damages, a jury determination of damages, or is he bound by the first judgment?
Well, in this case, he's bound by the first judgment because the court said that. And so I think the purpose here today is to determine if the district court erred. That's what we're here to decide. And I think, right or wrong, the district court did exactly what this court told it to do. And that was, these are the damages of this case, go have a trial on fault, which is exactly what we did. And quite frankly, Judge Mahoney said it in his ruling that the plaintiff is bound by this determination, as is the defendant. So my client wasn't able to go to trial and say, you know what, $285,000 isn't sufficient compensation for what I went through. I want $500,000 or $1 million. My client was just as bound by that damages determination as was the defendant. So it was restrictive to both parties. And Judge Mahoney recognized that. But he said, that's the law of the case. That's the mandate from the Court of Appeals.
Did both sides argue that before the second trial?
I'm sorry, argue what?
Did both sides argue that the judgment was $285,000? Those were the damages?
There was a petition for review. That's what the court's getting on, where the Dr. Castaneda petitioned the Supreme Court for review of that first decision. We suspected that might be an issue, and my client was in advanced age. And so we joined in that request just to get that issue determined at that time. But the Supreme Court denied the petition for review. At that point in time, my client accepted the court's decision that the damages were determined. Now, Dr. Castaneda initially pushed back on that, but as I'm sure this court has seen, subsequently, Dr. Castaneda stipulated to that. And in the pretrial order and pretrial conference, during the trial, jury instructions, at all of these important events, he stipulated that the damages had been determined. And if he wanted to preserve that issue for appeal, he absolutely had to renew those objections and make that a part of the record at that time.
Is that an invitation to error?
Is that an invitation to error?
Is he asking the court to err by stipulating?
I think he was conceding that argument. I don't think it was an invitation to error. I think he was conceding that point.
Well, now he says it's an error.
Well, I think that's.
He didn't say it was an error then.
That's correct. I think he's changed his position. And I don't.
Should we permit that?
Absolutely not. No, I think it's no different than if someone were to file a motion in limine to keep out a key piece of evidence, and then that evidence is offered and you fail to object to it. It then comes into evidence, but you've not objected to it. A motion in limine is an interlocutory ruling, just like this issue of damages. Even though the district court had ruled that the damages are determined, that's an interlocutory ruling until it happens at trial. And so if Dr. Castaneda wanted to preserve that, he had to raise those objections as the case went on during trial, in the pretrial conference, and jury instructions. There's no preservation on the jury instructions. He agreed that these are the instructions we should give to the jury. Yeah, and I was going to address the cross appeal as well. Just real briefly on the fault issue, because that might be the one issue where I think most of this is asking the court to review the prior decision, except with this argument about Dr. Jones's fault. And I just want to point out it's in the briefs. I don't want to spend a lot of time on it, but I think you can see from the sections that were cited from the record, I actually gave Dr. Castaneda every opportunity to tell the court what fault was there on Dr. Jones, and saying that there were issues or whatever it was, the vague comments is not specific enough. It's not adequate under the law to state that what Dr. Jones did fell below the standard of care. He had to state, this is what the patient's presentation was, this was the diagnosis, this was the treatment, this is why it fell below the standard of care. There is no testimony in the record in regards to that. Dr. Castaneda chose not to have an expert witness testify in this case for whatever reason. There's no expert testimony that says that Dr. Jones fell below the standard of care. And perhaps most importantly, Dr. Castaneda admitted that he was going to use the implants that Dr. Jones had done. He testified that when my client, Mr. Rodina, switched his treatment, he was in the process of preparing a new lower partial using the same implants that Dr. Jones had input. And I asked him, why are you going to use those same implants if you're claiming that Dr. Jones did something that was negligent or below the standard of care? He didn't have a good answer for that. So
he didn't have an answer, or he didn't have a good answer.
I don't remember what his answer was specifically, but he didn't. I don't recall. I'm not sure he even answered the question, to be honest. So, I don't think there was any error in the court granting the directed verdict with respect to the issue. With respect to the cross appeal, the only issue that the defendant has raised with respect to that issue is that the damages were not liquidated. And respectfully, I think it's incorrect. I think the case law makes it clear that the damages are liquidated when they can be determined. There's a difference between liability being determined and damages being determined. What the defendant's really arguing is that liability hadn't been determined. He's saying, well, we had to have a trial on fault. That's true. We did that. But in the cases that we cite, the one with the mechanics link, there was questions about whether other contractors might have some contributory negligence. There was questions about on the insurance case about what the limits were and what coverage was going to apply. So there was no certainty on any of those as to the exact amount that was going to be paid, but the number was determined, which is the same as our situation. We knew as of May of 2020, May 27, 2020, I think is when the default judgment was entered. And at that time, the court set the damages to $285,000. Our position is the damages were liquidated at that time. And the case law is clear that even though there may be a good faith controversy or there may be a question about liability, that can still be determined at a later date. But that's a damages issue, or sorry, a liability issue, not a damages issue. The damages had already been determined. And so we believe the proper calculation with respect to prejudgment interest would be from May 27th of 2020 going forward.
Is that the date of the judgment?
I believe that's the date of the default judgment. Yeah. And since there's not been a judgment awarding prejudgment interest, our position is that the prejudgment interest would run until that judgment is entered. So if this court were to agree and enter that judgment, we think prejudgment interest would run until that opinion is issued, and the post-judgment interest would begin thereafter. And so specifically what we're asking for, Your Honors, we're asking that the court affirm what the trial court did. There's a lot of history to this case. We've been through a lot. We've had a trial. Dr. Castaneda wanted his day in court. He got his day in court. He had a chance to argue the fault of Dr. Jones. He didn't prove it, and that's the way it goes. He had a chance to argue the fault of my client, Mr. Rodina. He didn't prove it, and that's the way it goes. He had his opportunity, and now he's coming to the court saying, hey, give me another crack at it. And that's just not the way it works. There had to have been some error that occurred. There was no error. The district court followed the mandate from this Court of Appeals precisely, and it should be affirmed. And we also believe that the court should award prejudgment interest from May 27, 2020 going forward, because the damages were determined at that time.
Thank you. I guys are both wonderful. Exactly to your time. Thank you very much.
Thank you.
Any other questions? 3 minutes. I think the first question I'd like to ask is what's your response to this preservation argument?
Your Honor, I think, and the preservation argument is addressed in my reply brief, but the short version is that when the case came back, Dr. Castaneda challenged the damages in his answer. A motion to strike got filed. Dr. Castaneda opposed that motion. The court ultimately said, hey, I think this is part of the mandate. I'm bound by damages. At that point in the process, Dr. Castaneda had no meaningful ability to challenge that part of the appeal. And if you look at the Harsh versus Miller case that I cite there, which is a case where there were essentially two separate track cases filed by plaintiffs, there's a federal case and a state case, and plaintiffs asked the court to stay the state case while the federal one ran its course. And they said no. And the plaintiffs appealed that, tried filing an interlocutory appeal. What the Supreme Court said is, you made your objection. You have no duty to, this isn't a final appeal just because you would have to acquiesce otherwise. You've made your objection. You can point to the record where you think it's an error, and that's what you need to do to appeal it. I think that we've got the same thing here. He opposed it at the first chance he got. The court ruled on it. He doesn't have an obligation to say, I still think the court is wrong at every turn he conceivably could thereafter. I think he's preserved that argument by making it his answer and through the motion to dismiss stage. I think what the court has to look at is, can we point to that in the record? And I've pointed to that in the record. I do want to briefly touch on the right to trial by jury question, because one of the things I heard was that Dr. Castaneda may have had a right to trial by jury, but guess what? There was a trial in front of the jury. I think what that ignores is all of the precedent by the courts, especially in recent years, that talk about damage caps and how the right to have a jury decide damages is an essential and critical component of the right to trial by jury protected by Section 5. So saying he got part of a jury trial when it doesn't include one of the essential elements protected by the Kansas Constitution isn't good enough. I do want to briefly talk about the use of the mini implants, and I direct the court to page 9 of my brief, which is this back section that talks about the trial testimony, and it talks about Dr. Castaneda's explanation for why he didn't take the mini implants out at the time. The short version is, but he testified that that's what he proposed to Mr. Rodin, and Mr. Rodin told him he didn't want to do that. So he was allowed to use what was there because Mr. Rodin didn't want to go that direction. Those citations are in the record. Or find some helpful. I want to point that out. With regard to the cross appeal, I do want to briefly touch on that issue because I didn't talk about that on the front end. With regard to the question of whether this was liquidated or not, all of the cases that the cross appellant cites are these all or nothing cases where everybody knows exactly what the damages are, and it's either the defendant is liable and they're liable for all of them, or the defendant's not liable and so there's no damages. This isn't that case because we had no idea until the jury came back whether the jury would assign 0%, 15%, or 100%, or any number in between. So this is not a situation where we knew it was for sure it was either going to be 285 or 0. It could have been any number in between, and because we had no idea what the number was going to be until the jury came back with their verdict in this case, damages didn't become liquidated against Dr. Castaneda until that. Barring any other questions from the court, I will rest and simply say that we would ask that the court reverse the district court and give Dr. Castaneda his right to the trial by jury.
Counsel, you heard me ask your opponent if you had invited error. I'll ask you, did you invite error in this case?
No, Your Honor. I don't think that. I think that.
Have you taken inconsistent positions? During the trial, you argued one way and now you're arguing differently.
No, I don't think so at all. I think that we pointed this out on the front end as soon as we could, and the court ruled against us on the motion to strike. I think at that point, all we can do is move forward. But that doesn't, at that point, we pointed out that we don't think that the district court is applying the mandate correctly. I think that we can't just continue to object every stage. I don't think we're under any obligation to do that. I think we've made our objection and that preserves it.
Thank you.
Thanks, Your Honor.
We will take this matter under advisement and subsequently issue a written opinion. We appreciate the arguments, and they were very helpful. Keep going. This case is State of Kansas versus Avron Dion Slaughter. Would the parties state their appearances, please? First for Mr. Slaughter.
Morning, Your Honor. My name is Randall Hodgkinson.
And good morning, and may it please the court. My name is Kendall Kaut, and because I'm not on the brief, Your Honor, my bar number is 27221.
Okay, could you spell your name for me, please?
Absolutely. My first name is Kendall, and my last name is Kaut.
Okay, and you are or are not on the briefs?
I believe there was an additional filing done by Mr. Minahan, but I was not on the original brief. It was filed in this case, Your Honor.
Thank you very much. Okay, Mr. Hodgkinson, did you wish to reserve any time?
3 minutes, please.
You got it. And we're ready. Okay.
Your Honor, my name is Randall Hodgkinson. I'm here today on behalf of Ms. Slaughter. Your Honor, this is a aggravated domestic battery case out of Johnson County. We raised several instructional issues, and I just want to at the front recognize that I also had a cumulative error issue in this case, and the Kansas Supreme Court, since we filed briefs in this case, has said
And threw that out, didn't they?
has said that even if all of these were instructional errors, because they weren't objected to, that you will have to turn a blind eye to any cumulative effect of those, which I disagree with, but I understand that this court is bound by what the Kansas Supreme Court says. It's be controlling on any cumulative error should you find more than one error in this case.
Okay.
So I only had a couple of comments then on the issues that are presented, particularly on the first issue with regard to the failure to give a lesser included offense instruction for a simple battery. The prosecution in this case and their brief, I think, agreed that such an instruction would have been legally and factually appropriate. Therefore, the district court should have given it. So the real debate there is whether it's clear error in this case, whether there's a real possibility that had a simple battery instruction be given in this case, could one or more jurors have believed that to be the more accurate verdict in this case, and therefore effectively not. And Your Honor, this actually was the first case I had under this, I guess, fairly new aggravated battery version. And it's very specific, and I think that's relevant to this question then of what the effect might be. Because it's not necessarily just the general aggravated battery cause bodily harm. It's very specific with regard to knowingly impeding breathing or blood supplies. And that being the case, I think that's really where the real possibility that a different outcome is apparent, is demonstrated by our facts, that particularly because it's not just enough that the victim's breathing was constricted, but that my client had to have known that he was constricting her breathing. And particularly given the facts, and this is actually related in some level to the unanimity instruction, but there were different things, different evidence brought forward by the prosecutor in this case about how maybe the victim's breathing was constricted, whether it was by him actually choking her, or whether it was by him maybe dragging her in a way that caused her head to go to her chest, which could also be him testified to constrict her. And in those cases, the culpable mental state, this could be quite different. The jury could do that quite differently. And so in light of sort of the first of all lack of medical testimony in this case, regard to any sort of understanding of her loss of breathing or things like that, and particularly in light of the what are described as changing testimony with regard to the nature of the constriction of breathing in this case, is there?
What do you mean change in testimony?
Just that, for example, she talks about how, he had his hand around her and caused her not to breathe. But at other times she said, well, actually, I didn't really have I wasn't actually ever constricted with breathing at various points. That she was able to talk during this, that she was able to scream during this. And that's all evidence that one or more jurors might look at and say, we have a real question of whether one, her breathing was constricted, but even more importantly, even if her breathing was constricted, did my client know that he was doing that in those different situations? So we think that the facts in this case do demonstrate clear error, that had the jury been given the option of simple battery in this case, that there's a real possibility that one or more jurors would have come back with that verdict. The second point that I wanted to talk about with the court had to do with the fourth issue with failure to give a limiting instruction with regard to prior bad act evidence. In this case, during cross-examination of the victim, my client's attorney asked the victim and client about their relationship, and the victim's response was, "Yeah, we don't see it in our eye because he's been beating me." And our position is that that is evidence of prior bad acts under 60-455. The prosecution argues that those are too vague or ambiguous to be prior bad act evidence. And I think that that's pretty specific. It's not just that he did bad things or that he was a bad person in some way, but that he did specific acts and that those, in fact, are the exact sort of acts that are being charged in this case. And so that is extremely relevant as it goes to clear error for that issue. That I'm reminded, because I've been around doing this long enough, that once upon a time, failure to give a limiting instruction for prior bad act evidence was automatic reversal. And then our Supreme Court said, no, that's not true. And yet, I think it's still true that prior bad act evidence is inherently prejudicial. That's why we have 6455, because we have general concerns about a jury's ability to sort of separate that kind of evidence out without proper instruction from a court.
What's the impact, though, of the fact that this came out during cross-examination? Was this a case where he asked a question he didn't know the answer to? The answer, in a sense, was it invited? I mean, what would be the need for a limiting instruction in that situation?
Yeah, I mean, it's not an evidentiary issue. If this was an evidentiary issue, I think it would make a lot of difference how the question came out. It's like you opened the door to this and it came out. And so that's not this issue. We're not arguing about that. I mean, I don't know. But, could it have been an evidentiary issue? I don't know, but we don't get there because there wasn't an objection. But that being the case, then it doesn't make any difference. The requirement for a limiting instruction doesn't make any, isn't determined based on who generated that evidence. It's just, was there prior bad act evidence admitted? Yes. And then the district court should limit that. I mean, I guess the district court could sui sponte done something about this from an evidentiary standpoint. That I don't understand why this, whatever. That didn't happen. And so the jury heard the evidence. Our issue is, did the jury get proper guidance with regard to that evidence? And our answer is no. And I mean, this is just like general, some sort of prior bad acts that aren't really relevant to the case in front of the jury. The jury heard in this case, he's done domestic violence on me before. And, that has to be perhaps the most prejudicial kind of prior bad act evidence they can think of in a domestic violence case. For that reason, we think on that issue that there is a real possibility that had the jury been properly instructed how to use that prior bad act evidence, the verdict could have been different. Your Honor, I don't have anything else on the other issues other than what we have. I would submit them on the brief.
Any questions?
Thank you, Your Honor.
Thank you very much. You'll still have your rebuttal time if you'd like it.
Thank you, Your Honors. May it please the court, Kendall Tout on behalf of the state. I'll go in the order that Mr. Hodgkinson went in as well, but obviously happy to address any other issues this court may have to ask about as well. As it pertains to the aggravated domestic battery, the state has conceded that instruction for the lesser included offense of domestic battery, legally and factually, does have to be given, because the standard of review for that question is just, could there be any evidence that a rational juror could have? But given the standard of review, because the trial counsel and nobody else asked for the instruction is clear error, the standard must be, would this court be firmly convinced the verdict would have been different? And here the evidence is just overwhelming that there was strangulation in this case. Before even assessing that, I think it's useful to take a step back because Mr. Hodgkinson is correct. There aren't a lot of aggravated domestic battery cases that have gone up since that statute came into being more recently from our legislature. All that is required for a conviction on that statute is to either impede the normal breathing or circulation of the blood,
That's a far different wording than the prior statute. So this has become a very specific crime, is it not?
Yes, Your Honor, Judge, I would agree that it's a specific crime related to strangulation.
And where you have a series of events, what you have here, I'm struck by the fact that the unanimity instruction was not given. If there's a series of things of events which I think you would see that occurred here, I can see some jurors thinking, well, this was a strangulation and this was an impeding of the breathing. And so you have at least less than unanimous verdict. So I have some concern.
Sure, Judge Hill, I think for that purpose, I agree when trial counsel in this matter had stated there are two separate incidents. Factually, there are two separate incidents. But I think it relates to what is our legal standard for evaluating unanimity. Given that De La Torre case we cite from the Kansas Supreme Court, we know this is all in the same location. It's that apartment that she has in Olathe, Kansas. The time frame is not very long because it all happens in that instance. She's kicking the wall, so the neighbor, Jacob Patterson, eventually calls the police, and the incidents aren't factually distinct. I think it's similar to, we had an attempted murder case, and somebody's beating somebody nearly to death with a bat, goes over for a second, and then starts beating somebody with a different bat. There wouldn't be a fresh impulse there, which is that third prong you can also use. So legally, I think that's why the unanimity instruction is not required, because I think they're all the same impulse. The defendant, in this case, Mr. Slaughter, was upset because Ms. Short had the temerity in his mind to say, hey, I don't appreciate you coming over here uninvited when we're not even in a relationship anymore. And that's when he panics, freaks out, and does these awful acts to the victim in this case. As it pertains, though, to that clear air standard, I think there are just several facts that make a clear strangulation occur. The first is that the victim in this case defecated herself. There's testimony from the officer that there is a stain on her robe. There is testimony from the victim about an expletive that is explained by the defendant in this case about you. As yourself, since we're on YouTube and have some students here, I won't go over all of it, but it is quite graphic and explicit for what was said. We have testimony from the officer that is something that can happen if a person is strangled. So that is far greater than even the normal impediment of breathing that would happen. We have testimony from the officer who was trained in domestic violence to say that there was petechiae, which relates to the red dots that were in the victim's eye, and that is also caused by strangulation. We have testimony in this case from the neighbor that says, I heard kicking on the wall, and the victim said, I think he's trying to kill me, which would relate to something more than just being punched or a quick tussle that might happen in an apartment. All of those things are just overwhelming evidence of strangulation. On top of that, we have the victim was so distraught and thought she might die in this case that she went by her neighbor's apartment a few days later to thank her neighbor for calling 911 because she thought she might die. All of that is substantial evidence of strangulation happening in this case because it did. As it pertains to the prior bad acts evidence, because Mr. Hodgkinson addressed that, I'd like to address that as well. The statement itself, I think, is what frames this. I want to be explicit about what was said. The defense attorney asked, you had not quite seen each other eye to eye during your relationship. And the victim responds, no, he was beating on me. Now, it is possible, I think, to believe that's prior bad act evidence. But it's also possible to think when she says, he was beating on me, and the question is, did you see eye to eye, that she believes she's answering her question about what happened that date. Ambiguity only requires saying both possibilities exist. I certainly agree with Mr. Hodgkinson. It is possible to view that statement as her saying, he was beating on me all the time. And that's the unstated clause that's not presented by the victim. But it's also possible to view that as, no, he was beating on me because she's presented a bunch of testimony about being strangled with a right hand around her neck. She's presented testimony about her neck being pushed into her body and losing consciousness. And she's presented testimony about kicking into a wall from what happened. And I think both are reasonable interpretations of that statement.
So you're saying you interpreted for her being to say, you all didn't see eye to eye. Yeah, that's right. Because he was beating on me. That's why we didn't see eye to eye. So it was a direct response to the question.
Yes, Your Honor, Chief Judge Arnold Berger. I think it could be a direct response. It could be either one. And given those cases, we provide, say, when there's ambiguity, we don't presume it's a prior bad act. On top of that, the prior bad act instruction not being requested by the defense, I think matters in this case because he was in the courtroom and the defense attorney would have had the opportunity to see how did she react to the question, what was her mindset, how did she see when she answered it, and by a learned counsel, Mr. Gazah, not requesting the instruction, it provides some evidence that it didn't strike him that that answer was either non-responsive because there's no objection, or that some instructional issue needed to be provided to comply with State v. Gumby or the requirements of KSA 6455. So I think the failure of the defense attorney to request that instruction in this instance means it's some evidence this didn't strike him as, hey, I need to give the instruction, or Judge McCarthy was instructed, hold on, counsel, don't we need to give a prior bad acts instruction? And those folks who were in the room, who heard the testimony, could react to what was the demeanor, how was the question answered, do have a little bit more insight. And that's why I think some deference should be given there. And that's why the instruction should not have been given.
You can also interpret it as being poor work by the defense counsel.
Judge Hill, that would be a possibility, but that issue could be raised in a 60-1507 motion later on and correct that, or the direct appeal could have brought up that it fall below that standard.
You aren't really asking us to give deference to the failure of the trial court to do something.
Judge Hill, and in this instance, because I think in this instance, because there's ambiguity, that relates to there should be some deference in this instance to what happened. There are certain issues that are so clear cut, we wouldn't give deference. For example, if she had said, oh, he beat me all the time. In August, he beat me. In September, he beat me. Well, there, we wouldn't give any deference to the trial court because the error would be so clear. But in this instance, I think some deference could be given. Now, I agree, Judge Hill, if you say, I'm not persuaded by that argument, I think the court could still fall back on the statement in and of itself is so ambiguous, or for the purpose of clear air, it is one statement, he was beating on me. So we're just talking about a handful of words. That wouldn't overwhelm all the evidence presented at trial, even if that argument, Judge Hill, is not the most persuasive one I've given.
Any questions? Thank you. Rebuttal.
Remember, I just wanted to address one question that I don't think I answered your question very well, or at least you appeared to me to not find my answer very satisfactory. But I wanted to just clarify what I'm talking about when this is on page 2 of my brief, that the victim in this case said she could breathe while my client's hand was around her neck, and the only time her breathing was impaired was when her head was pushed to her chest. That's a record, volume 6, pages 41 and 42. That she said she never lost consciousness and was able to breathe the entire time. That's record 6.
She thought
44.
She said she thought she may have lost consciousness.
I'm saying that there's competing evidence here, and this is at least where I'm citing to for the propositions that I was making to you earlier on. And that she acknowledged she was being dramatic when yelling in order to try to get her neighbor's attention. That is there evidence of supporting that there was strangulations? Yeah, there's evidence of that. Is it so overwhelming in light of the admissions that she made on cross-examination? No. And particularly in light of the culpable mental state requirement for this very specific kind of crime, if the jury had been given the option to consider simple battery, is there a real possibility that one or more jurors may have said that seems like the more correct verdict? We think that that's the correct answer in this case.
Thank you very much.
Thank you, Your Honor.
Very well argued case. We will take this matter under advisement and get to our decision, hopefully in a timely manner. Thank you. Okay. Last case of the morning is State versus Newsom. Please state their appearances, please. First from Mr. Newsom.
May it please the court, Adrian Newsom, Pearson, counsel Jacob Noah, for Kansas Appellate Defender Office. May I please request 3 minutes of my time here to turn for a moment?
Did you say 3 minutes?
Yes, ma'am.
Can I please report the affidavit of State of Kansas prepared by Deputy District Attorney Kayla Raymer of Wyandotte County District Attorney's Office.
All right, Mr. Noah, you can begin.
May it please the court, This is Adrian's direct appeal from his jury trial conviction, 1 count of rape. Adrian has maintained his defense that the allegation made in this case was fabricated, that this was a consensual encounter, and that the complaining witness fabricated that allegation to either preserve her relationship with her boyfriend or to avoid gaining a reputation as a cheater. His ability to present that defense was hindered substantially due to the state suppressing a very large discovery file that contained a massive amount of exculpatory and impeachment evidence until the night before his case in chief. And it should be noted that the state's fault that Adrian sat in jail for over 2 years while he was waiting for trial. That was largely COVID related, but then give the state a lot of opportunity to make sure that it had complied with its obligations under Brady, that it had reviewed the information its investigators had collected to turn that information over to Adrian Newsom. Despite that, it was at 9:50 p.m. on the night before Adrian's case in trial or case in chief when this evidence was ultimately turned over.
I mean, after the prosecutor had already presented all their evidence, it was before the defense started their case that this was turned over.
Correct.
Did the state rested or?
Yes, I believe the state had rested. They presented their entire case, I believe, and not remained one witness left. But certainly, OY, the complaining victim in this case, she had been released from her subpoena. She had already testified. She had already been subject to a less than effective cross-examination due to the substantial delay in this. And I want to note that saying the state turned over the evidence is a fairly favorable characterization towards them, because it was really Adrian's trial counsel, Diane Caprice, who did the work here. It was Diane Caprice who tried to first uncover these messages at prelim, but that proved unfruitful because OI had deleted them, or I think deleted them at that point in time. And then Ms. Caprice filed 2 different motions for this specific discovery. One for approximately 2 years prior to trial on February 2020. Where she asked for the text message between OY and SC. And then a second one in May of 2021, where she asked once again for the text messages and also any surveillance footage from the surrounding businesses, from the hotel, that sort of thing. And both times the state came to court and told the district court that the evidence didn't exist. They didn't have it in their files. They turned over everything to trial counsel. Then it was.
Let me ask you a factual question. I don't know if you, but when she said in prelim that I deleted them, but they were then found, does that mean she didn't delete them, or did they somehow recover them after she deleted them? You know,
my understanding, and maybe I am drawing an inference here, but my understanding is that those were pulled from SC's phone, the co-defendant's phone, that they would have been essentially had the
so
entire
she may
time.
have been deleted them, but the recipient.
Yes.
Had not.
Well, yeah, the other partner to that text exchange had not deleted them. They were collected by the police through that. And then it was at trial. It was Ms. Caprice who was the one who heard whatever it was that brought her attention to the fact that she hadn't received all the evidence that SC's attorney had received. It was then Ms. Caprice who, on her own, contacted the Palmer Springs Police Department to get that evidence disclosed. It was Ms. Caprice who went over there and that at night to have it turned over. And it was Ms. Caprice who reviewed that evidence throughout the night so that she could discuss it at least somewhat intelligently with the district court the next day. In comparison, the state at best did nothing during this evidence over, but in reality, they did it. The disclosure of the evidence they represented or they did not exist after Adrian filed his 2 motions.
Does it make any difference what their intent was?
It doesn't. Not for the purposes of Brady violation. It could have exposed different ethical connotations if they had maliciously hid this evidence and known about it.
So we can assume that it wasn't malicious, that it was just a, understandable mistake or whatever, but that doesn't matter.
I don't know if it was an understandable mistake.
I know that
for our purposes, I'm comfortable with assuming it wasn't malicious because it doesn't change the Brady evaluation at all. Because,
but let me ask you, how should we look at this? Okay, if there was a lot of this evidence in the Palmer Springs police station, can the state just ignore and not pass the police department if they have any information. Is that okay? Under Brady?
No, the state's not allowed to sit back and be willfully ignorant. They have an affirmative duty to make sure that they know all the information their investigators know. It was their responsibility under Brady to go to Bonner Springs Police Department and collect everything that they had.
Well, that's the point of Brady, isn't it?
Correct, yes.
You just can't sit back, oh, did we have that? Oh.
Yeah. And that's why the distinction between whether or not it was malicious or just wanton negligence, I think, at least Mr. Priest believed it was in this case.
In fact, the court called it at least negligence. The court said it was disturbed what was going on. Right?
Yeah, the court was disturbed by the evidence not being presented or given to the defense well before. I do believe they referred to it as negligence. In fact, if not specifically, that's certainly the crux of their ruling.
Well, after 2 years, you would think there'd be some negligence.
I agree with you, Joe. I think the state was wantonly negligent in this case at a minimum for not collecting evidence.
The state argues that no harm, no foul. You had the chance to question police officers that were still available about all this evidence. So you got in what you wanted to get in. What's your response to that?
My response is that,
and I mean trial counsel, I know.
The response to that is what that issue turns on is whether or not we were able to effectively use it in Adrian's trial, whether or not we were able to use it to the same degree we would have been able to use it had it been turned over in February of 2020. And it's impossible for that to have taken place in this case. That might fly if we're talking about, a few photographs of the hotel room, which is what Mr. Priest thought she was going to be getting when she went over to the police department. Imagine her surprise when she got this massive discovery file. But no, she wasn't able to effectively use that. There's 3 points I want to make to that fact. First, and broadly there, she wasn't able to effectively assimilate it to her case in chief. She wasn't able to use it to effectively challenge the state's case in chief. And it at least deterred her client's decision by how she wasn't able to effectively communicate what was in that discovery file with the client beforehand. On the first issue, we can see on the record, Mr. Priest is still transferring these exhibits that she's been curiously reviewing over the night onto one thumb drive over her lunch hour. That's not an effective presentation of this evidence. I'm certain this court's reviewed it. It is a very cumbersome exhibit. She did her best, but it is not as if she had detailed exhibits point by point that she could present to the jury for them to easily digest.
We go back to an actual question because it relates to the state's argument that, the defendant had access to this information. What was it? His phone that they'd gotten the what she had deleted from. So didn't she have had access to that all along? Do you understand what I'm saying?
No, I apologize if I hadn't been more clear. It was SC who the co-defendant who this conversation was. So
okay, that's whose cell phone it was, not the defendant's cell phone.
Yes.
Okay, thank you. I appreciate that.
Additionally, you mentioned law enforcement. No trial, at least criminal defense attorney wants to put on their case in chief through law enforcement. The testimony is just not going to come out as persuasive as would otherwise. You're going to get shorter responses. And frankly, I'm not certain that they understood the significance of that discovery. Otherwise, you would assume that Bonner Springs would have turned it over to the prosecution early on in this case. And the lack of time is going to be the most important resource any public defender can have. The lack of time to review this also prevented Mr. Priest from being able to effectively understand the gravity of the evidence herself. As you can see during her case in chief, I would say she kind of goes along down the line of a red herring with whether or not the police gave a cigarette to SC. I think had she had this evidence longer, she might have found that probably isn't the most persuasive way to spend my time. I'm going to focus on OY's credibility because that's the witness that really hurts Adrian's case, not SC so much. And then obviously, I'm troubled by Adrian's candid and reasonable response in his sentencing. This delay impacted his willingness to testify at trial, and that To me, it is reasonable. He shows up to court on the day of the state's he realizes he's only seen half of the state's evidence. He doesn't know what could be used to impeach him or what sort of wrench can be thrown into his cross-examination based on evidence he's never seen. He sat in jail for 2 years. He should have been prepared for this trial. Mr. Priest would have been prepared for this trial had she gotten the evidence on time. State suppression prevented her from being able to do that. And then, obviously, importantly, they weren't able to cross-examine OY, at least not effectively, because they didn't have the impeachment evidence. And that's great. I mean, the whole reason appellate courts don't reweigh evidence on appeal is because we put such great weight in the jury's ability to see the witness testifying, to watch how they react to difficult cross-examination questions, to watch how they react to favorable examination questions, and to balance that against other testimony. But nobody got to ask, oh, why she told the jury that she didn't want to smoke marijuana that day, when it was clearly her plan at 11:35 to do so, and to frankly distribute the marijuana for this party. Nobody got to ask, oh, why she was sending flirtatious text messages to SC and asking if they could be discreet when she's claiming to the jury that she would never have cheated on her boyfriend. Nobody had to ask, why we couldn't find these messages on her phone, because they appear to be pretty damning. And you deleted them. So what should we draw from that inference? And nobody got to ask, why she misrepresented that she was trapped in a bathroom. You couldn't call the police. So we can see her on surveillance footage walking around with her cell phone after the alleged assault occurred, and then returning to the man who allegedly assaulted her. That's an odd choice. Yeah. OY probably wouldn't have been able to convincingly explain all those inconsistencies and odd decisions to a jury. I think that would have made a difference. Seeing that would have made a difference if Mr. Priest was able to present that evidence effectively to the jury, and just being able to throw it all onto a thumb drive at the last minute, put it on in front of the jury so that they maybe could navigate it, isn't an adequate substitution. The state's brief, where they were not able to identify at least some portions of the impeachment evidence that we identified in our brief, highlights that. If the state, who had this evidence for months while they were writing the record, or what had the record of guilt for months while they were writing the brief, couldn't identify every piece, I don't know that this court can assume the jury found the same.
Do we know they had it? I mean, maybe they just never asked for it. Maybe the Bonner Springs Police Department had it. It was just lazy. I mean, do we know that the prosecutor actually was using that information during trial?
Oh, I'm referring more to the appellate prosecutor being able to identify all of the information in their brief that they thought. But no, to your question, we don't know one way or the other. And again, it doesn't matter because it is the state's obligation to familiarize itself. And I'd like to highlight the holding in Augers, United States Supreme Court case, because we did ask for this evidence specifically twice. It says when the prosecutor receives a specific and relevant request, the failure to make any response is seldom, if ever, excusable. That's effectively what happens. It's actually worse than making no response. They misrepresented to the court, whether intentionally or not. It doesn't matter. The evidence doesn't exist. And the court relied upon that when it denied the motion for discovery. That prohibited Mr. Newsom from being able to make this defense.
And you're starting to get into your rebuttal.
I appreciate the notice. I will stand for any questions, but otherwise.
I do have. Seems like the district court in this specific case, in denying the motion for new trial, and some other motions that the defense made, was saying that, well, hold it, the jury, you got to bring this up, as far as the trial court level, you got to bring this up and so forth. But in reading your brief and so forth, was there a difficulty, even if some of this evidence was turned over at trial and the jury had it? Was there a problem? It sounds like it was a problem, even if the jury wanted to view some of this evidence, that it was a problem in being able to actually see this evidence, that was presented. as far as electronically on tapes and so forth. Can you speak to that?
Yeah, just briefly, it's mostly related to the delay in preventing Mr. Priest from being able to effectively make easily digestible exhibits presented to the jury. She wasn't able to make a single exhibit that could be published during her case, and instead she just had to submit an entire thumb drive that contained all of the evidence that she wanted the jury to look at on before them. Obviously, some of this is surveillance footage. It's got a lot of irrelevant evidence. It wasn't able to be redacted or short beforehand. So it made it a very difficult and cumbersome exhibit for any lay witness to just sit down and review and go, aha, there is the evidence that we need to identify. And that would have precluded their ability to effectively take into account Adrian's case. Thank you.
Thank you very much. Trailer, I think for your benefit, I'll say you were not trial counsel in this case.
I was not, Your Honor.
I think you're going to get some hard questions.
I was anticipating it, and I expect nothing less from this panel. So I may please the court, Kayla Rayler, on behalf of the appellate of the state of Kansas. I'm going to not trial counsel. First of all, Your Honors, I would like to point out that there is a typographical error in my brief, and I apologize about that. I noticed it last night when I was preparing for today on page 10. The second line of the second paragraph, it states that Newsom explained that the state looked at SC's file and it was not identical to Newsom. That should not be there. It is identical. In fact, actually, SC's, it's not in record, but SC's file was less than Newsom's file. There was no actual evidence given out in SC's case. So it had less in it than Newsom's case file.
Counsel, can you just tell me your view of what happened here?
That's a great question, Your Honor.
Nice, easy question.
It's a wonderful softball. I wish I could give an explanation, and I can't. What happened should not have happened. It's not good. But I think the crux of all of this turns on whether or not there's prejudice. State does not disagree that this file should have been retrieved. There should have probably been a little bit more diligence in checking with Bonner Springs if it existed, especially at the preliminary hearing when they are talking about text messages. Or Mr. Priest knew there were text messages.
That's why she kept asking for it.
Exactly. But also she didn't do a subpoena to the police department. She had these concerns. And this is not a 1507 proceeding. And yes, the state has the obligation to get exculpatory evidence. But also defense has an obligation to sniff out their hunches. Again, not a 1507 proceeding. This is not there was not a Van Cleave hearing on this. But the question is, was there prejudice? And the state's position is no. And here is why. Most of the evidence that has been cited as being exculpatory goes to the alternative charge of rape, where the victim was unconscious due to alcohol or unable to consent. It does not go to the charge of which Newsom was convicted of, force or fear. Even if all of that evidence came in at trial, the state's position is it would not have changed the jury's verdict because the jury did not convict him of unable to consent due to the marijuana consumption and the alcohol consumption. That is about 90% of this impeachment evidence.
But it doesn't it really show whether or not she was believable?
I think it goes to credibility, the text messages specifically. Because let's talk about the video really quick, and then I'll go into the text messages. There's this big to-do about the video and how she looks like she's perfectly sober. Well, there was testimony. She was walking perfectly fine, but SC says she was high, she was drunk, she was out of it, but yes, she was walking completely normally. So that doesn't necessarily cut her credibility. The text messages can go to credibility. And the problem in this case is that we are forgetting the timeline of some of the discovery. I use quotes because appellant Newsom wants you to believe it was discovered at 9:50 on day 3 of trial, but Mr. Priest stated that she had concerns after Detective Haney's testimony on day 2 of trial. And nothing
Well,
was
does that
done.
make it better then? You got a little 24 hours then?
Here's where I'm going. Here's where I'm going. Hear me out. Day 3 is when SC and OY testified. She had this inkling that there are these text messages. There's this stuff before SC and before OY testified. And then she did not ask for OY to remain under subpoena so that if these did exist, she could have put them on through OY to judge her credibility.
I think 3 different occasions, but there's nothing there.
I understand, and it's unfortunate that it happened, but as a trial attorney, sometimes it's more, and I apologize for the language, it's more damning when the victim is not on the stand, because the victim doesn't have the opportunity to explain away, as Newsom argued, to come up with these stories. Sometimes it's more beneficial to not have them on the stand and get the raw messages in, because defense counsel can make the argument that they want based on that exhibit versus giving OY the opportunity to say whatever they want to put them in context. And that's that can have a lot of weight with the jury, because the defense gets to put up their, oh, look, she's talking about getting high as F. Does that sound like a victim to you? In close, she gets to make that argument and there's nothing to rebut.
There's also the ability to prepare the defense witnesses. Correct? If you have that information, you could prepare them days in advance, because you have different questions you can ask them because you have evidence that supports the premises of your questions. And the defense was denied that. I mean, virtually denied it because the night before, when you're busy copying, you aren't preparing your witnesses because you're copying. That I have trouble with that, counsel.
I understand the conflict, and it's very hard. And Ms. Caprice did what she could in the middle of the time. She did the best that she could, but she had suspicion about these text messages, and she crossed OY on them. And I understand she may have wanted to prepare her witnesses better, but most of her witnesses that she in fact called were solely to put in this evidence. It wasn't additional witnesses to support Adrian's defense.
But we're looking at it from post-trial. We're not looking at it from pre-trial when she could have prepared her portion of the defense different. So it's difficult for us to make a judgment post-trial because all we can see is the effect on her case.
Sure. And I think what the court needs to focus on in this particular case is not necessarily even the text messages at all. It's SC's testimony. SC testified. He was the co-respondent in this case. He pled. He entered a plea for what he did to OY. And he testified that Newsom joined in and that OY was not willing. Now, in their brief, they make a big to-do about the meaning of unwillingness and how that does not equate to consent. However, in getting to it, Rockwood, the state said that the state is not required to prove a rape victim told the offender she did not consent, that she endured sexual intercourse against her will. And SC, the co-respondent in this case, testified that she was unwilling to have Adrian Newsom join her in bed while she was performing fellatio on SC against her will, according to her testimony. You take out her testimony just on SC's testimony, and that he raped her from behind without her even knowing. That's SC's testimony.
But SC, when you look at the record, so he didn't seem like a very good witness for the state, even though he got a deal to testify, wouldn't you say? Because SC was implying that OY was a willing participant, that after that this situation with them, she went into the bathroom and had a shower. That she saw all these hickeys on her, and then the biggest thing on her mind, how was she going to explain this? And that she didn't want her boyfriend to be there. And that she asked him to be discreet, even before anything like this happened. Isn't this, when you're looking at OY's credibility, doesn't this go against her credibility if that had been brought in and if she could have been examined by the defense?
I think this is a lot of what would I do in this situation? I think that's a lot of what this argument is. And it's unfortunate that we treat survivors of rape in this manner. We have no idea how a woman or a man would respond to being violated, being in the most vulnerable position that they could possibly be in, having a man's penis in their mouth being violated from behind. I testified that she was in flight or fighting. And she was in flight. She was afraid, and we see it all the time in criminal cases, that sometimes they go back to the man. Sometimes they fight back. Sometimes they take a shower. Sometimes they try to forget. And sometimes they just freeze. And that's what we have here, is that we are now trying to say what we would have done in that situation, having never, hopefully, have been in that situation.
But we would enter a trial assuming that the victim is telling the truth and the defendant is telling a lie. What you said is horrible and would be horrible for anybody, but isn't the defense entitled to have all the information necessary to cross-examine and challenge her credibility? I agree that's awful, but knowing that this information existed that would support the questioning that defense would ask, seems incredible. And perhaps this isn't a proper question, but I don't think any attorney could look at this case and think, what? A box full of evidence in the middle of trial? I don't think any of us would think that was a good thing.
I don't disagree, Your Honor, and it should not have happened. If Ms. Caprice, the other thing I think this court also needs to look at, I understand it's the middle of trial, and judges are allowed to run their courtroom how they want. But also, we need to ask for time if we need it. And I don't think that was done here.
She asked for mistrial.
She asked for mistrial. She didn't ask for time to prepare to present these exhibits.
But along with that, too, you've got a jury right there. I mean, and you don't know what's going to happen to that jury if you continue the case for 3 or 4 days.
100% judge, but that falls on the city and a mistrial at that point. It wasn't asked for. And that's my point. If she thought, other than the asking for a mistrial, if trial counsel thought she was at such a great disadvantage other than asking for the mistrial, she could have asked for more time and didn't. Part of this, again, it's horrific and it should have never happened. Let me be abundantly clear. But some of this is invited. She released OI from her subpoena. She asked for SC to remain under subpoena and not be transferred back to the juvenile detention center, but she didn't call him. She didn't call him. Now, the text messages, they all relate to SC. And what Newsom is trying to do here is equate any potential consent to SC to automatically being consent to Newsom. And that's not what we have here. Even if OY went there to have sex with SC, that does not equate to consent with Newsom. She did not want it. She did not consent. SC said she was not willing to have Newsom join it.
Well, is she entitled to formulate her arguments by having the evidence when she could formulate her arguments a little more reasonably, not receiving the evidence at 9 o'clock the night before she starts her case? Is she entitled to time to prepare? As counsel, you'd like time to prepare, wouldn't you, counsel? Was there a Brady violation
I mean, the question of a Brady violation comes down to three prongs. Yes, evidence was withheld. Yes, the evidence could have been favorable to Newsom. The question is prejudice. And that's my position, is that Newsom can't show prejudice with the withheld material because, again, he was acquitted of the marijuana and the alcohol form of forming, or not acquitted, I apologize. He was not found guilty of rape by somebody who could not consent, which would have been most of that evidence. Yes, there is a credibility determination, but a lot of that evidence also still came in as impeachment evidence through other witnesses. So they had the evidence. So these text messages would have been cumulative, which would have made it not material. So
he was found not guilty of aggravated sodomy, right? Yeah.
I believe so.
Okay.
Yeah, because there was some evidence, I believe, in and I will defer to the trial record on the facts of this particular case. I believe when this case was charged and went to prelim, I believe that there was some testimony that there may have been anal penetration, but that did not come out at trial. So yes, he was acquitted of that charge. But if I remember the trial record correctly, I think that's what it is. I think, again, what happened is horrific, and it should not happen. There should be more safeguards in place, unfortunately, that it didn't happen in this case. It's not a record. I don't think it will happen again based on new systems.
Do we know if the prosecutor had all that evidence?
She did not.
We know that from the record.
It's not in the record. I'm telling you as an officer of court, she did.
So she hadn't even gone to the kind of Springs Police Department.
As far as I'm aware.
And, I mean, that's not a one way or the other in this case. I just which would point more to negligence than intentional malfeasance.
I believe it was negligence more than anything. I would also point out for the court, and you know, it's not necessarily it's positive, but let's think about the ages of the people that are involved in this, because SC was 16 or 17 when this occurred. OY was 17 when this occurred. Adrian Newsom was in his 30s. He was 12 years older. He was close to being 30. He was the only person of that age in that hotel room. I had another point in my head and I lost it, so I apologize about that. And one reason for the ages is once SC turned 18, Newsom and SC were in the same housing unit in Wyandotte County Detention Center, and that's when Newsom started asking SC to lie, to help him, and fabricate letters. So that shows that there is a consciousness of guilt for what he had done.
And that was all introduced to trial.
Yes, it's the record. I cited to it in my brief. I believe I don't remember the page on the top of my head, but I did cite it in my facts. If there are no other questions, again, I apologize that this happened. It should not happen. I think this is a good lesson for all prosecutors across the state that if somebody believes that there is evidence out there, we have to do our due diligence, because if we cannot prosecute a case with an open file, we should not be prosecuting that case.
Any other questions? Any rebuttal?
Hey, please support. I will be brief. I know I went some of my time here on. I just really have two notes I want to make. First is SC certainly didn't testify that Adrian raped OY. His testimony was largely favorable to Adrian. States left on the one sort of confusing bit of testimony that included double negative with the question and answer. So it's read literally this actually being what the state is purporting it to mean. But regardless, if you can look at the context and see that his testimony is largely favorable to Adrian.
Counsel, your opponent says you have not shown prejudice. Everything else is there for the Brady violation, but you haven't shown prejudice. What's your best answer?
My best answer to that is that had OY had to get up on that stand and be cross-examined with this evidence, that would have made a difference in this case.
How?
the jury would have seen her react when she realized in the moment that I've been caught perjuring myself throughout the entirety of my testimony. I lied about all the events that led up to this alleged assault. I lied about all the events that occurred after this alleged assault. Now, there is no determinative evidence that shows she lied about the alleged assault itself. None that shows that she was being truthful about it. But we have evidence that shows she lied about everything up to and everything after. I'm guessing her reaction when she found out that that evidence existed would have been mortifying. And that if you're in Kansas jury who have seen that reaction and discredit her testimony altogether, you're correct. It goes towards her credibility. That's what all of this goes towards.
Couldn't the defense have called her back?
It would have been incredibly difficult to do so because
I mean, she was released from the subpoena, but they could have attempted to call her back.
they could have attempted to call her back. I'm not sure what sort of delay that would cause. And
what's your response to counsel's statement? Well, counsel never asked for a continuance to.
I was about to respond to both those with this question. I would ask you to put yourselves in the position of that counsel in that moment. She's got what she believes to be an innocent client who has been sitting in jail for 2 years waiting for a trial. Any further delay based on what is entirely a state error, a state blunder, a egregious error is just further prejudice to him. I don't want to speak for Mr. Priest, but to me, any sort of continuance would have been out of the question. We need to either have this dismissed or we are proceeding further. So the problem with having her brought back in is twofold. One, it's going to be difficult to get around that specific day. Subpoenas you have by statute, at least there's no specific time frame, but reasonable opportunity to move to quash them. And two, here's the thing with this evidence, she needs to be appointed counsel to advise her Fifth Amendment rights at this point. I mean, there's evidence that she committed felony interference with law enforcement. There's evidence that she perjured her testimony. There's evidence that she distributed marijuana, all within this withheld discovery. So it's going to be a substantial delay that shouldn't have to go to Adrian at that point. This is completely a state fault.
Does the volume of the evidence make a difference here?
Absolutely. I do not see how Mr. Priest, and I respect her work, I do not see how she could have effectively viewed all of that evidence over the course of the night.
Even if none of it ended up being exculpatory.
Sure, you still have to do your due diligence and review the evidence to the best of your ability. Obviously, some of it did. She caught a good portion of that exculpatory evidence. I don't think she caught all of it, but she certainly wasn't then also able to effectively create exhibits to get witnesses in on that day. And the state essentially makes the point that she didn't do a good enough job asking for a Brady relief. She's reviewing all this evidence. She doesn't have time to also then go review Brady and all of this progeny and make sure she's making the perfect, certainly precise request or objection at that point. She did a tremendous job with the issue itself.
Thank you very much.
Thank you very much.
Thank you very much. Very well-argued case. We will take the matter under advisement and enter a decision hopefully in a timely manner. With that, our morning docket is done and we'll stand in recess until like 1:30. So thank you all. I need my 2 Well, now. Really get a little class. Yeah, you take a bunch of